I disposed of the tray.
You what?
I used it, and I.
Oh, you used it then. Okay, so it didn't stay on the tray.
Right. And I disposed of the tray.
Yeah.
Thank you, Judge. I have spoken to Mr. Emmons about this case. It's going to do.
Today's case is a courtroom reality check in real time. A defendant charged with operating while intoxicated causing death, and the intoxicant is allegedly cocaine, yet he tests positive again after arraignment. The judge isn't just hearing excuses. The judge is measuring risk, honesty, and public safety. And when the story starts collapsing, I threw it away turns into I used it. This hearing goes from routine to bond revocation fast. Watch closely. One bad answer can change everything.
Do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC, and then I need to address his. It's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was positive.
Hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't
From August 28th?
I don't believe that's the date. Let me check.
Mr. Allen?
Yeah, mine dated August 28th.
In terms of his testing, I have on, so he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right. And on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th. And then
So then he got tested on the 16th he was ordered. He wanted to test there. He tests on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he's not any longer.
Here's the key legal backdrop. This isn't a trial moment yet. This is pre-trial supervision and bond compliance. When someone is charged with a serious offense, especially causing death, the court typically imposes conditions like drug testing and reporting to community corrections. The purpose is simple: control risk and ensure the defendant follows court orders. Now, notice the tension. There's confusion about the progress report date and testing system between counties. That matters administratively, but it does not excuse a positive cocaine result right after arraignment. The judge's mindset here is, if you can't comply with basic conditions now, how can the court trust you outside? Viewers, do you think the system should allow county testing loopholes, or should conditions be strictly enforced regardless of geography?
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows
He
him
tested here today.
here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet,
I was
Judge.
informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community corrections would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth. To
Okay.
do that testing, if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Okay.
So let me get this right. He's charged, I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with.
Yes.
He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
Yes. He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And
I
then you
threw it
just
away.
smoked it.
I threw it away.
You threw it away? How's that work? Where do you throw it? It's gonna be a long conversation. Where do you throw it away?
There was a little bit left. I used
I
it.
know.
I disposed of the tray.
You what?
I used it and then.
Oh, you
Oh, the
used
tray.
it then. Okay, so it
There was only a
didn't
little
stay,
bit.
it didn't stay on the tray.
Right.
And I disposed of the tray.
Yeah. Yeah. Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he was coming today.
Please.
And yeah,
I'm printing them now.
you're printing him.
I haven't touched it since.
So somebody needs to answer for me, why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I
I
don't.
have my theory, Your Honor.
I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how. I
Oh,
have-
really? Hold on.
I've never been-
You know what? The thing I hate more than anything is when somebody lies to me.
This is where credibility gets wrecked on the record. The judge isn't confused about drugs, he's testing the logic of the explanation. Look at the sequence. I threw it away becomes I used what was left, and suddenly the court hears a version that sounds like I disposed of it by consuming it. That's why the judge presses repeatedly, where did you throw it? Because the story matters less than the truthfulness. In bond hearings, the fastest way to lose freedom is not just failing a test, it's lying about it. Judges can tolerate bad decisions. They don't tolerate being misled. Audience question. When someone is facing a death-related charge, should the court treat relapse as a medical issue first or as a public safety emergency?
Honestly, I'm not.
Okay. We'll just make sure that you, because it has to be in your system in order for you to test positive. And if you, that it's been signed.
Counsel, approach briefly. You want to see this? That's my copy, though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive, 22nd to 7 days later.
Yeah. 7 days later. And a little bit he threw away. That Go ahead, I'm sorry. I'm messing up your story.
Oh, I know. But all I've done is I've used it in the chair that I sold. I've used it in the chair. And that was it.
When it's second,
No, I have not.
okay. Well, we'll tell him that, but, you know, medically.
I know. I want to do this. I want the truth.
Okay.
To
To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Yeah, Judge. And
Just so that we know.
thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to fix that problem when he testing theory. He is working and he did voluntarily come here today and take a test. So he's asking you to
Not say that, right? No.
No, you didn't have to say.
All right, anything else?
All I can say, Your Honor.
tell you the truth.
Okay.
My cousin doesn't allow anything. It's possible. I have friends at my mother's house, but cousin's house to do work down there. Okay. Because I'm gonna eventually reside down at my cousin's house.
All right. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
first one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Except that he can't follow the court's order. I don't know how he's going to do treatment. And the other thing is, he doesn't test when he's supposed to test.
Yes, Judge.
So it seems you may have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
This outcome was driven by 3 courtroom realities: risk, compliance, and credibility. The judge clearly connected the dots. If the intoxicant in the underlying charge is cocaine and the defendant tests positive again after arraignment, that's not a minor violation. It's a direct signal of ongoing danger. Then the explanation deteriorated under questioning, and once the court suspects dishonesty, trust collapses. In bond decisions, judges weigh whether conditions can actually protect the public. Here, the judge concluded they could not, so bond was revoked and the defendant was remanded. Bigger takeaway: pre-trial release is a privilege conditioned on responsibility, not a blank check. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.